Think you own that masterpiece you just prompted an AI to create? Think again, because U.S. copyright law has a shocking answer for you. Welcome to our podcast, Artificial Intelligence Papers and Concepts, curated by Dr. Satya Malik. Before we begin, just a quick disclaimer. This podcast is for informational and educational purposes only. Nothing we discuss here should be considered legal advice. If you need advice for your specific situation, please consult a licensed attorney. I have a rather fitting confession to make before we really jump into the substance today.
Oh, setting the stage early, I see.
Yeah, well, I always enjoy breaking the fourth wall with you, our listener, and today the secret we're sharing is it's basically the core of what we're talking about. Both myself and the expert guiding this deep dive are entirely AI generated.
It is pretty ironic, isn't it? We're artificial intelligence, parsing the legal frameworks that govern our very own outputs.
Exactly. So for you, the learner joining us today, our mission is super targeted. We are deconstructing a massive, up-to-the-minute legal report.
Right, the report is called AI-Generated Works and U.S. Copyright, and this is fully updated as of March 2, 2026. This is the absolute frontier of where the law stands right now.
We are going to separate the persistent myths from the reality of what you can actually legally own when you use generative AI.
And we'll also explore the hidden traps of infringement that might be sitting right there in your current workflow.
Yeah, it's a huge landscape. We'll look at the bedrock rules of U.S. copyright, some honestly bizarre historical court cases, and breaking news from the Supreme Court.
Plus the specific software dilemmas for developers and the legal minefield of AI training data.
But before we get into the foundational framework of the report, we do have a quick message. This podcast is sponsored by BigVision.ai, a consulting and product development company that helps companies of all sizes build computer vision and AI solutions. You can reach them at contact@bigvision.ai. Okay, let's unpack this. To really comprehend where AI fits into the current legal paradigm, we have to start at the bedrock, which the report anchors in the U.S. Copyright Act, Title 17.
All right, Title 17. The foundational premise there is that copyright protects original works of authorship that are fixed in a tangible medium.
But it's not absolute protection, right?
Not at all. It gives you a specific bundle of exclusive rights, like the right to reproduce or distribute, but it intentionally leaves certain things completely unprotected.
And that relies on this boundary called the idea versus expression dichotomy, which is super critical.
It is the absolute core of it. Title 17 explicitly says copyright does not extend to any idea, procedure, process, system, or concept. It only protects the author's original expression of that idea.
So relating this to your everyday life as the listener, if you have an idea for a revolutionary app or a fantasy novel about a wizard school, the law gives you zero protection for the concept itself.
Exactly. The idea of a wizard school is entirely public domain.
But the specific original text you write, the dialogue, the precise code for the app, that specific execution is your expression. The law protects the execution, not the concept.
And when you apply that to generative AI, it reveals exactly why so many users misunderstand their legal standing.
Because when you type a prompt,
You are fundamentally just providing an idea or a concept. You might describe the lighting, the mood, the artistic style in painstaking detail. But legally, that prompt is merely the conceptual framework.
the machine is the one doing the expressing.
Precisely. The AI model takes that high-level concept and executes the final expression by calculating the specific arrangement of pixels or tokens.
So the prompt is the idea, and the output is the expression. And since the machine executes it, the human operator is disconnected from the legally protectable part.
Which brings us to originality. The Supreme Court modernized this definition to require independent creation plus a minimal spark of creativity.
Independent creation just meaning you didn't copy it, it originated with you.
Right, but that minimal spark of creativity is an absolute requirement, established in a 1991 case called Feist Publications. It involved telephone directory.
Oh, right, the sweat of the brow doctrine.
Yes. The sweat of the brow doctrine argued that if you spend immense effort and resources compiling something, even just a factual phone book, that sheer effort should be rewarded with a copyright.
But the Supreme Court totally rejected that. They essentially said, effort does not equal authorship.
You could spend 1,000 hours sweating over a data set, alphabetizing names manually, but without a creative spark in how you select or arrange that data, no copyright.
Which is pretty devastating to AI users who argue that spending 40 hours tweaking a prompt should grant them ownership.
The law does not reward the labor of prompting. It strictly demands a creative spark in the final execution of the expression.
And that expression has to come from an author with a capital A. Historically, courts have defined an authorial work as an original intellectual conception.
And they draw a very sharp line between the person who requests a work and the person who actually creates it. Think about the work made for hire doctrine.
Like if I hire a painter to paint a portrait, I give the idea, but the artist is the author.
Unless you have a very specific written agreement transferring that copyright, or they're your direct employee. The legal philosophy is that authorship requires a human mind directing the final tangible output.
And that output has to be fixed. That's the final pillar, fixation. It has to be captured in a stable medium where it can be perceived or reproduced.
Right, ink on paper, code saved to a hard drive. But in computational spaces, a purely transient image in volatile memory that vanishes when the power is cut is not fixed.
The AI has to render it into a stable file format. So we have this framework entirely dependent on a human mind, providing creativity, executing an expression, and fixing it.
And to understand how courts apply this to AI, we actually have to look backward. Long before generative AI, the U.S. legal system had to grapple with non-human creators.
Yes, the historical precedents. Before we talk about latent space, we have to talk about macaques.
The monkey selfie case.
Naruto v. Slater. This is such a fascinating case for the listener to know. A crested macaque monkey named Naruto basically grabbed a wildlife photographer's unattended camera and took some amazing selfies.
And animal rights advocates actually sued on behalf of the monkey, arguing Naruto was the author.
Which sounds kind of funny, but the legal consequence was huge. The Ninth Circuit ruled that animals lack statutory standing to sue under the Copyright Act.
They didn't just dismiss it as a joke. They analyzed the statute and concluded that the entire apparatus of U.S. copyright law is inextricably built around human beings.
Because you can't incentivize a monkey with a legal monopoly.
Exactly. The court cemented the principle that non-human entities simply do not fit the statutory definition of an author.
So animals are out. But what about plants? That leads to Kelly v. Chicago Park District.
This one tested whether natural forces could be harnessed by a human to create a copyrightable work. An artist claimed copyright over a massive living wildflower garden in Chicago.
He designed the layout, planted the seeds, and claimed the living garden was his original work of authorship.
But the Seventh Circuit held it was not copyrightable.
Because a living garden relies on natural forces. The artist isn't making it rain or controlling how the roots grow. Nature is executing the expression.
And because nature is constantly changing the arrangement, the work is never stably fixed by human hands. The human initiated the process, but the non-human force dictated the final expression.
It sounds exactly like pressing generate on an AI. You plant the prompt, but the algorithm dictates the pixel growth.
That's the perfect analogy.
But there's one more case here. Urantia Foundation v. Mahara. What if the non-human entity is a ghost?
Or celestial spiritual beings, yes. The claim was that these entities channeled text through a human patient.
The Ninth Circuit didn't debate if ghosts were real. They asked if a text generated by a non-human entity could be copyrighted by a human.
And they established a really vital principle. The raw channel text wasn't copyrightable on its own, but the human beings who compiled, selected, and arranged those raw revelations into a structured book provided enough creativity to secure a copyright for the compilation.
So the raw output of the non-human is unprotected, but a human's creative arrangement of that output can be protected.
Exactly. Some element of human creativity must exist in the final work.
It's kind of funny having to seriously debate monkey selfies and spiritual channelers, but these quirky cases perfectly laid the groundwork for today's AI legal battles. Monkeys, plants, and ghosts all share the exact same legal fate as generative AI.
They aren't human. And that historical perimeter was the direct target of the ultimate legal stress test for generative AI, which brings us to Thaler v. Perlmutter.
The AI as sole author case. Stephen Thaler tried to register a visual artwork called A Recent Entrance to Paradise, but he explicitly listed his AI system, the Creativity Machine, as the sole author.
He noted it was created autonomously by machine. He basically wanted to force the Copyright Office to accept an AI author or explicitly reject it.
And the Copyright Office flatly refused the registration, so Thaler sued.
In August 2023, the D.C. District Court affirmed the refusal, granting summary judgment for the Copyright Office. They held human authorship is a bedrock requirement.
Thaler then appealed to the D.C. Circuit and tried to use the work-for-hire loophole right. He argued he owned the machine, so he should own the copyright like an employer owns an employee's work.
But the D.C. Circuit completely dismantled that in March 2025. They ruled that the word author in the Copyright Act is restricted exclusively to human beings.
And they clarified that work for hire governs the transfer of a copyright. It doesn't alter the requirement that the creator must be capable of holding a copyright first.
And AI cannot be an employee because it's not a legal person.
And this leads to the major breaking update. Thaler petitioned the U.S. Supreme Court, and just recently, on March 2, 2026, the Supreme Court denied cert.
Denying cert means they declined to hear the appeal. So the lower court's ruling stands as the definitive law of the land.
So for the listener, the door is officially closed on zero human authorship works in the U.S. You can't just set up an automated content farm and claim copyright protection.
The dream of fully automated protected content is legally dead.
Here's where it gets really interesting. With autonomous generation invalid, the focus shifts to collaboration. How much human involvement crosses the threshold?
Which is the focus of the U.S. Copyright Office's 2023 policy statement and their 2025 Part 2 report. The core mandate is transparency.
You have to explicitly disclose the inclusion of AI-generated content when registering and limit your claim only to the human-created portions.
This was intensely tested in the Zarya of the Dawn case. It was a comic book where the creator wrote the text and arranged the layout, but used Midjourney for the images.
The Copyright Office approved the registration for the human-authored text and the human's creative compilation of the pages.
But they completely excluded the Midjourney images from protection.
Meaning you own the comic book, but a third party could theoretically extract a specific AI-generated image of your character and use it, and you'd have no grounds to sue them for copying that specific image.
Because you never own the image itself.
And creators often push back on this. They say, I spend 40 hours crafting a prompt. I'm the director.
The prompting paradox. This was the focal point of the Theatrodopera Special case. The applicant tried to register a highly acclaimed AI-generated image, arguing they used extensive iterative prompting.
But the review board in September 2023 affirmed the refusal. Prompts alone aren't enough because the AI system determines the expressive elements.
When you use Midjourney, you interact with latent space. The AI model uses a random noise seed and predicts the exact color and placement of every pixel based on its training weights.
So legally, you are just a client giving instructions to an AI artist. You don't own the painting.
But there is a spectrum. Zero human works get zero protection. But if you take a raw AI image and spend hours manually painting over it in a digital editing program,
you're fundamentally changing the expression through your own hand.
right, your edits might be protectable, the human contributions are protectable, but the underlying AI generation remains unprotected.
So the practical guidance for the listener is to keep receipts. Maintain a granular evidentiary record of your workflow. Save your prompts, your edit histories, your layers.
You have to be able to clearly delineate exactly which brushstrokes were the machine's and which were yours.
And always disclose the AI use if registering. But this rigorous separation extends way beyond art. It profoundly impacts software development.
Software dilemma. Software is protected as a literary work, but only the expressive code, not the underlying function.
If a developer uses ChatGPT to generate a large block of Python and pastes it verbatim, that code lacks human authorship.
The developer provided the idea, the AI executed the literary expression. So the pasted code has an incredibly low likelihood of being copyrightable.
Which is terrifying for tech companies. If you don't own your core proprietary code, a competitor could just copy it.
But to mitigate this, developers need to use AI more like an autocomplete tool, suggesting a few lines alongside human writing. That makes the whole program much safer as a human-authored compilation.
But ownership is just half the dilemma. The other half is the massive liability risks regarding training data.
Like the Doe 1v GitHub case, a putative class action regarding GitHub Copilot.
The plaintiffs were developers who published open source code on GitHub. And open source doesn't mean free from rules. It often requires proper attribution.
The developers alleged Copilot was trained on their code and stripped away that attribution when generating suggestions, violating their licenses, and the DMCA.
In January 2024, a court order narrowed the case. They dismissed the DMCA and broader infringement claims because AI models don't just copy and paste massive blocks of text.
They predict tokens. So proving direct reproduction of exact code was incredibly difficult.
But the court kept the contract-based theories alive. The claims that GitHub violated specific open source licenses by failing to provide attribution are still viable.
So if you're a developer listening right now, treating an AI output as yours without adding significant human expression means anyone else can likely take it.
You really need to identify what you wrote versus the AI, keep your version control history, and disclose AI use.
But there is a hidden minefield here. Even if you don't care about owning your AI output, you still have to worry about whether your output or the AI's training is infringing on someone else's copyright.
The stakes here reach the billions of dollars. There's input infringement based on training data and output infringement based on what the AI generates.
Let's start with training data. AI companies argue that ingesting copyrighted material to train models is fair use.
Fair use is a defense that balances four factors: purpose and character of use, nature of the work, amount used, and market effect.
AI companies argue their use is highly transformative under Factor 1 because they're extracting statistical correlations, not just displaying the original works.
But copyright holders vehemently disagree on Factor 4, market harm. Look at Thomson Reuters v. Ross Intelligence.
Thomson Reuters owns Westlaw, which has proprietary human-written legal summaries called headnotes. Ross Intelligence used Westlaw cases to train a competing AI legal research tool.
In February 2025, a Delaware court granted partial summary judgment, finding Ross infringed on Thomson Reuters copyrights.
And they entirely rejected Ross's fair use defense on that specific record. The court focused heavily on market substitution.
Ross was using specific legal summaries to build a competing product in the same market. That's not transformative fair use, that's commercial infringement.
So the idea that training is always fair use is a myth. But Ross was a niche market. What about training on the entire internet?
That brings us to the New York Times, Microsoft, and OpenAI. Major news publishers suing LLM creators for using their articles.
The publishers argue the ingestion process requires making unauthorized digital copies in memory, and that the models can regurgitate near verbatim excerpts.
In April 2025, the court resolved motions to dismiss. The core copyright infringement claims largely survived.
Meaning the publishers have a valid, judicially recognized path forward, though fair use hasn't been decided on the merits yet.
So the courts are drawing battle lines on training data. But what about the outputs? This leads to the INRI OpenAI copyright infringement litigation MDL.
A multi-district litigation where authors are claiming that ChatGPT outputs infringe on their books.
They argue that if you ask ChatGPT to write a sequel using their characters, the output is an unauthorized derivative work.
In October 2025, a New York court concluded plaintiffs plausibly stated a prima facie infringement claim based on outputs.
They denied OpenAI's motion to dismiss that specific theory. So output-based infringement is officially a surviving legal theory.
It places liability not just on the AI company, but potentially on the end user deploying that output.
Using an AI tool is not a legal shield, but the courts aren't universally condemning AI companies. Look at Cadre v. Meta.
Authors sued Meta over training the llama models on their books. But in June 2025, a ruling granted Meta partial summary judgment on fair use.
Which seems contradictory, but it was based on a very specific evidentiary record.
The plaintiffs struggled to provide concrete evidence demonstrating how the computational use of their books caused direct market harm to their novel sales.
So it's a limited ruling. It didn't broadly bless all AI training, but faulted those specific plaintiffs' record. Future cases will be fought trench by trench.
To summarize all this, the core belief here is that knowledge must be applied. The law in 2026 is clear. Human authorship is mandatory for ownership, but human accountability remains when an AI infringes.
You do not own the AI's output, but you are legally responsible for how you deploy it. It is a crazy balance of risk and reward.
Very precarious.
As we conclude, I want to leave you, the listener, with a final puzzle to mull over. If AI-generated pieces belong to the public domain, but a human compilation of those pieces is copyrightable.
Like the comic book case.
Exactly. Imagine you generate 10,000 unique AI images. You meticulously curate them, categorize them by intricate emotional themes, and arrange them into a highly complex digital archive.
The pieces are unprotected machine outputs, but the architecture of the archive is your original intellectual conception.
At what exact point of curating a massive dataset of AI art do you cross the magic threshold from using a machine to becoming an author? Where exactly does the curation end and the creation begin?
That is exactly the boundary the courts will have to define next.
Thank you for listening to this deep dive. If you enjoyed our discussion, please subscribe to our podcast for more insights.